Well, it has been an interesting week in India's evolving understanding of the medieval sedition provision, Section 124A. Now, Monday saw the government file an affidavit where, quite unexpectedly, it proposed to quote-unquote reconsider and re-examine the provision. Tuesday saw the Supreme Court suggest putting the provision on hold in this interim period. And on Wednesday, which is today, we saw in the Supreme Court order with far-reaching implications on civil rights and civil liberties. So what is this order and why is it hugely significant? Well, here are the four key takeaways. Number one, Supreme Court has allowed the government to go ahead and to reconsider and re-examine the provision, but this is not the key takeaway. Number two, Supreme Court has rejected the government's defense of Section 124A and refused the government plea to continue registering offences under sedition even while the government reconsiders. And this brings us to the hugely important number three. Supreme Court has effectively suspended Section 124A till further orders. The Supreme Court said that it hopes and expects that no further FIRs are registered under Section 124A. Number four, equally significant, Supreme Court has directed that all pending cases, all cases filed under this provision must be kept in abeyance. Now, what has been the court's rationale? Well, the Supreme Court noted that it had discussed the issue at length. In fact, so much so that in an unconventional move, the three judges, rose from the court and went into their chambers to discuss this issue in private for nearly 30 minutes. So the Supreme Court has held that it needed to balance the issue of national security and integrity along with the issue of rights of individuals. The Supreme Court expressed concern about the possible misuse of the provision. The CJI, in fact, also recalled how just last week, the Attorney General had admitted to the scope of misuse of this provision in law. Now, legal and civil rights experts have often pointed at the data on low conviction rates to argue that this law is a potent tool to harass and silence critics. In fact, here are the numbers. Between 2015 and 2020, India saw a total of 356 cases being filed under Section 124A. This led to arrests of over 548 people. However, despite these large numbers, only 12 people were convicted in merely 7 cases. Interestingly, minutes after this order, the Union Law Minister Kiren Rijiju took the opportunity to remind the court of the Lakshman Rekha that should not be breached, that should not be crossed. But a number of key questions still remain. Number one, how effective will this stay be on the ground? Number two, what will be the timeline for this reconsideration by the government? And number three, will the Supreme Court continue to hear and decide on constitutionality of sedition in parallel? Perhaps the Supreme Court holds the answers.